Welcome back to Legal Alternative Podcast with me, Sam Pawson. Join us there by Nils. Nils, we're back. How are you?
We are. I'm good, Sam. It feels like a long time. It is a long time.
I think it is a long time. It's 3 weeks since we released, since we did the last one through both of our breaks. Did you have a good Easter?
It was very good. It was very good. I was jealous of your trip to Turkey.
Yeah, yes, made it. People kept saying, "Am I all right going?" Yes, it's quite a big country, so I think I'll be fine. So made it back safe. I had a nice week off, which was lovely, and then back into it. I'm suited and booted again. We had a seminar this morning, employment law updates. That was wonderful. Yeah, and back in the swing and back on the pod, which is always a pleasure. Nils, you're kicking this off this week, immigration.
Yeah, I know you've got a really interesting case, which we're both keen to discuss because it is quite a big change. So just quickly from me, there's post 8th of April, immigration fees have gone up. We've spoke a lot on the pod about how it's getting more and more expensive to sponsor a worker, and post 8th of April, more expensive than ever. All of the main fees have gone up. So if you want to sponsor a skilled worker for up to 3 years for an application made outside of the UK, that is now £1,865, up from £1,618. If you're doing that inside the UK, that's gone up from 819 to 943. That's on top of all the other charges and payments that you need to make. Indefinite leave to remain applications, they've increased in price to £3,226. A naturalisation application fee now £1,709. And even if you're coming here as a tourist, that's getting more expensive. So the ETA, the Electronic Travel Authorisation, going up from £16 to £20. So families that are coming in, so a family of 4, 80 quid before you do anything. Also, they've increased the sponsor license application fee. That's also gone up quite a bit for large employers. 1,579 previously to 1,682, and for smaller 574 to 611. So these little increases obviously feed into what we've discussed on the pod many times. It's expensive. I think what perhaps we haven't discussed is this is actually high stakes stuff as well. To get it wrong, if you get it wrong, costs you thousands of pounds, and the more expensive it gets, the higher the stakes get if you get the process wrong. So it's really critical to have some advice. I don't think we've probably emphasised that point, or I haven't emphasised that point enough in the past.
Yeah, absolutely. Again, obviously, as we talked about, combined with the minimum salary requirements, it's very expensive. It's you're looking at £40,000-50,000 with fees and all the add-ons and time. And yes, as you say, it's a very expensive process, which I think politically is the idea.
Yes, I'm sure it is.
Yeah, in terms of recruitment of obviously UK-based employees, but with a labour shortage, it's a lot of sympathy for our clients and people who are looking to recruit. But as you say, if you are then going to go to that expense, you need to get it right. I think that's absolutely the pertinent advice.
Yeah, well, you could spend nearly £1,700 and be told this isn't correct, start again.
Yeah, absolutely.
For a modest sum, it's better to at least be as sure as you can be that it's right first time.
Yeah, absolutely. Moving on, I've got your favourite game, Nils. I've got some lovely pronunciation to do. So I'll give it one effort, and then they will thenceforth be known as the claimant. We've been practicing hard, so we've got, the case is Canal Lapali versus Loesch Energy Systems is the case. It's a Court of Appeal case. So as to be talking off there, Nils, before we went on, this is a case which, when you've been practicing as long as we have, that I've been advising something for a long time. And this is a case that has actually said that's the advice is changed. And you'll see through the history of this case, the original Employment Tribunal judged it like I would have done. But this is a Court of Appeal case that's overturned. So I'll give you a basic some facts of the case, and then I've actually got hopefully some solutions as well for the listeners. So in the case, claimant was offered a project manager's role at Loesch Energy System, made an offer in writing which was subject to a number of conditions. perfectly common, including satisfactory references, and a right to work check. That offer was accepted, but no contract was signed. In the intervening period between offer being accepted and the role starting, that offer was then withdrawn by the company, not connected to the conditions, i.e. the references or the right to work check, but for some unrelated reason. But so that offer was withdrawn with no payments whatsoever. I would have normally held historically that was correct because there's no contract and therefore there's no notice. And that, as I say, was the decision of the first tier, the Employment Tribunal. There was been no binding contract between the parties and therefore the company was entitled to withdraw their offer. That's then gone to the EAT that has disagreed and has held, and I'll go through the judgment, that the tribunal didn't consider whether the job offer conditions were the ones that applied after the contract began, and critically, that a binding contract had in fact been formed and the conditions operated to potentially terminate, rather than to prevent its creation, i.e. the job offer letter creates a binding contract, and that in order to terminate that binding contract, that reasonable notice would have to be given. So there has always been this concept of reasonable notice, generally in respect of resignations, where the contractual notice isn't deemed reasonable or there is no notice in a contract. The issue for me is that the tribunals held that offer letter was that binding contract. So in the case that the EAT has said that reasonable notice should be given, and in considering the seniority of this role, they have judged that 3 months notice would be appropriate. So the decision of the EAT is actually that this individual should be owed 3 months notice, which to me is quite surprising. And as I say, contrary to my historic advice. So, perfect illustration of the importance of this podcast. In terms of what would we do now? Because I actually think even with the judgment, there are some things that we can do. It's so the complexity is in that offer letter, in that forming the binding contract, dependent on whether these conditions have been met. Obviously, the difficulty here is the conditions. The conditions that they said were not the conditions which was the offer was withdrawn. So I think first solution potentially is to look at that offer letter and to make clear in that offer letter that the contract cannot be accepted until those conditions have been satisfied. So when we're going back to old contractual law of offer acceptance, consideration that hopefully says that binding contract hasn't been achieved. If that fails, my final view would be in the offer letter to establish a notice period within. So kind of the analogy of the probationary period. So to establish in that offer letter that during the point till the job starts, that it would be subject to a kind of probationary period of a week, so that you're getting a form of notice in, which isn't then the 3 months notice. So it's kind of a second chance saloon. That so condition of the offer is that it's an offer that's not accepted until those conditions have been met. If that fails, it's 1 week's notice. Would be my potential solutions to this, because again, it did surprise me when I saw the judgment, because it was contrary to my kind of previous advice. I don't know if you've got anything to add, Nils, on top.
I mean, it's really complicated, isn't it, actually? Because even with those safeguards, which I think are brilliant ideas, the contract is going to form perhaps sooner than an employer would like. So that the case that you discussed there, where they decided a 3 month period of time was reasonable. Presumably, even if you limit the amount of notice in the letter, that's still open to challenge as to whether it's reasonable.
I think so. I think that's exactly right. But I think it gives you a better indication if they've almost accepted that notice period in it, that has more chance of being reasonable. But it's absolute salient point for senior. I don't get me wrong. I understand the issue here. I think we've both seen it in practice, and we've probably seen it in our personal lives, where people leave high value jobs for another job, and they hand in their resignation, and then an employer, someone else revokes an offer, and people sometimes quite rightly upset about it. But it's, as you say, it's the idea of that contract being formed really, with the offer letter that is contrary to what I've always accepted the position of the law to be. And the position, as I say, with my position was the position of the tribunal. So I thought quite an interesting one, and something for clients to be aware of, really, to kind of look at that offer letter process even more so than always. We keep talking about these changes coming up, and the issue with 6 months changes to unfair dismissal. Obviously not absolutely pertinent to this, but it's I think for all listeners of the pod and clients, this is the time to be looking at our induction processes, our interview process, our offers, our contracts, because the stakes are so much higher now, both from this case and then obviously getting the decision right ultimately.
Yeah, absolutely. This could cost you dear, couldn't it? And just to go back to my point, the counter argument that I would use to my point would be, at the point an offer letter is issued, let's say you've got a 1 week notice period for a senior employee, you're on an equal footing, aren't you? So I would be arguing, if I were in the respondent's shoes, why are you now saying you wanted a longer period? The time for doing that has already passed. And if you weren't happy then, why all of a sudden are you now unhappy? So I think there are guardrails that we can put in for people that are practical, but I think it's going to mean HR departments and employers have really got to be on the ball now.
Yeah, I think that it is hard. I think the slight, as always in these cases, it does depend on the facts, and I think the general cases I've done this, often the withdrawal is for a reason that things have been discovered, sometimes some quite unpleasant things that would impact the conditions of the offer. So obviously, absolutely, if we've got a right to work, or we get a reference that is highlighting something, then that still would be a legitimate reason to withdraw the offer. That generally is when we've got another candidate comes out of the woodwork that's preferable. Is when this often happens, and often a withdrawal with no reason is done to save face, or save embarrassment, or save awkward conversations. So it's to prepare and be really serious. If we are making offers and we are using offer letters, in a considerable period before jobs are started and contracts are signed, that we need to be aware of this risk.
I'm just wondering, just final point from me, Sam, do you think it's worth putting a catch-all in? So you could say satisfactory references, right to work, check. Any other reasonable reason why we don't believe this job offer should?
Without making your offer letter sound too desperate, and I think it's all of that. I think it's that, and then your absolute catch-all. If that fails, it's a notice within a probationary period, or within a contemplation period. Call it what you want.
Yeah.
To kind of get around it. People may think 3 months notice isn't the end of the world on a one-off case equally. So I can understand all of that, but it's always good to learn, always good to have new knowledge.
I suppose what's interesting is someone has gone to the Court of Appeal there for 3 months' notice.
Yeah,
exactly. Huge sum of money, but yeah, I'm glad they did, because that's interesting.
It's good stuff, and that's it for this. For this week, I say out the office. I've been on the seminars. Rugby tomorrow for me, Leeds Catalan, which should be good as always. I know what you're up to, Nils.
Been watching quite a bit of rugby league actually at the moment, because all our clients have been in action.
Yeah,
so I've been really pleased to see clubs like Bradford performing well, Leeds performing well, Wakefield
very well. Yeah.
I think most of our clients are towards the top end of Super League, which is absolutely fantastic and great to see.
Yes. Good stuff. Right, we'll be back in your ears next week. Hopefully we'll be in person after a bit of a break, but it's goodbye from me.
And from me, thank you. Bye-bye.